You're watching Cablevision, Channel 14, Local Origination Programming, your hometown network.
Mind Over Matter. My guest today is Robert Cosgrove, an attorney and assistant district attorney working for the Norfolk County District Attorney's Office. And he's going to talk with us today, among other things, about the prosecution of the mentally ill and kind of what the policies and procedures are, what the process is once someone with mental illness is caught up in the criminal justice system. So, welcome.
Thank you very much.
I have here an article from the New York Times, and it basically reflects some material put together by the Alliance for the Mentally Ill that suggests that, quote, we estimate that approximately 1,000 homicides a year are committed nationwide by seriously mentally individuals who are not taking their medication. I wonder if you might respond to that or have some thoughts about that.
Well, when I hear that, I sort of mentally tick off some of the recent murder cases over the past 4 or 5 years that we've had in Norfolk County, where the defense of mental illness was raised. And I don't think that in any of those cases, actually, there was an argument that these people were on medication and were not taking their medications. But it may just be that we are eccentric in that respect. Where I have seen it come up is when somebody has been found not guilty by reason of insanity, and they have been through a treatment program, and the proposal is now then to release them, but they're taking some sort of medication that's necessary to keep them stable and under control. And the question then becomes very much, will the controls still be in place so that person will still be taking that medication? I would be very interested to know, I don't know if the article went into it, how many of those homicides, people who weren't taking their medication, were people who had been previously committed violent acts of some sort and were institutionalized. I don't know if those sorts of statistics are available, but that's a very great worry, that concern that our office has when somebody is taking medication and they have that past history, and now some of those controls are about to come off.
So how do you address that, or how do you build in assurances as a prosecutor? What are you able to do to try and build in such controls?
Well, it's a very hard thing to do because unless you actually have the assurance that a professional person is going to be observing the taking of the medication and recording that and notifying someone, there's no way to really be 100% sure. Even people who don't suffer from mental illness necessarily, but who must take some sort of medication, are not necessarily perfect about doing so. And if I can just give one quick example, one of the first cases I had as a prosecutor involved a motor vehicle homicide. And the gentleman charged was a taxi driver over in Brooklyn, and he happened to be an epileptic who was to be taking Dilantin. And for one reason or another, he had gone without his Dilantin for several days and was driving an elderly woman in his taxi cab, suffered a seizure. There was a crash and the woman was killed. And he was charged and indeed ultimately convicted of motor vehicle homicide under the theory that he had been negligent in driving that car, knowing that it was important that he take that medication and that he not do so. And there were other factors too. But the point I'd like to make is even with people who aren't mentally ill, that's apparently a problem. And I'm sure people in their own families where they have to take a morning medication for heart or liver or whatever know how easy it is to miss once or twice. And if public safety is going to be implicated, that's a very hard problem and a hard question you ask, and I don't know if I really have a good answer for you.
So if one's going to be cautious, then basically it's best to keep everybody locked up once they're appropriately adjudicated?
Well, that's a tough thing to say. That's a hard thing to say. And I think this whole area, and no doubt we'll have be coming back to this in the course of our conversation, you often see a tension between what's the ideal solution from a medical point of view or the clinical point of view or the patient's point of view, and what's an ideal solution from a public safety point of view or from the justice system's point of view, and often just the entire outlooks are worlds apart. Never mind the result in one particular instance. I think all of us would like to hope that as soon as we can get someone back on the street, back out there, and assure the public safety, that they'll be out there, and we can all agree to that in the abstract. But it's very hard to test and to predict outcomes in advance. And typically, I have to say that if we have a bias, it's a public safety bias rather than a patient-oriented bias.
So a lot of what influences our decision-making basically depends upon kind of what we consider to be our constituency.
I think that's true. You know, in terms of the person caught up in the legal structure, the legal structure gives him an advocate. It gives him a lawyer to present his cause. And on the other side is often the district attorney or law enforcement. And we're not totally on the other side because our mission in the best sense, and hopefully it works that way, is to see that justice is done. So we're not supposed to be out there just mindlessly being obstructive. But at the same time, it's important for us to push. And then somewhere in the middle of that is the poor medical professional as well, who hopefully is guiding the umpire in all this, the judge, if we're talking about a court proceeding, to making the correct decision and balance these competing interests of the public and the patient.
Would guilty but insane be a useful vehicle in the kind of repertoire of possibilities?
I think it might be. I'm not sure that I know enough about how it has worked in other states to have a firm opinion about that, but it might bring a measure of reality sometimes that the proceedings sometimes now lack.
Well, I would think one of the concerns your office has, because you do prosecute, if someone really is being charged and adjudicated, if the mental illness defense is being used, it's kind of all or nothing in Massachusetts. And I think the perception is that if they are found not guilty by reason of mental illness, they basically are committed until they are better, which could be a day, a week, or 100 years.
That's absolutely correct. And you have this sort of Alice in Wonderland reversal that inevitably goes on when you get that verdict of not guilty by reason insanity, whereby the defense attorney or whoever now fills the role as attorney for the former defendant, now the patient, well, the defense attorney has been up there strenuously arguing that his client was hopelessly insane at the time of the crime, and the prosecution has been hammering home that of course he was sane, and then the verdict comes in and there's suddenly a switch, and the advocate for the patient is now saying a day, a week, or whatever is all better now, and the district attorney's office or the prosecutor is now in the position of saying, well, wait a minute, we found this person to be insane, and we who were there a week, a month, however long ago, saying that he was not insane, now are arguing that he is. So you get into these kind of strange paradoxes by virtue of the way the system is set up.
All right. Well, maybe we'll come back to some of this after the break. Thank you.
We want to see our children succeed, but setting easy goals for our kids creates the toughest obstacle they'll ever face, because succeeding in the real world isn't easy. Help the effort to raise standards in America's public schools. Call 1-800-96-PROMISE.
Ago, there was a very high-profile case that I know has been of concern to your office, because now 20 years later there's been some question about when is this man ready for release back into the community. He did commit a homicide. He was found not guilty by reason of mental illness and was transferred with some controversy from the correctional system to the civil system a number of years ago. There was a lot in the press about that transfer. And then more recently there have been some questions about when is a man like this ready to return to the community. How has your office wrestled with those issues?
Well, it's interesting that you should mention this particular case following the discussion we had on taking the medications, because that was very much an issue with respect to this particular person. And this was a case where the patient had been charged with the murder of persons in his own family. There were family members still alive, so there were certainly some issues there. And there was also an issue in our minds in terms of the attitudes of this person towards certain women. So we had some very substantial public safety concerns, not only in terms of the facts of the crime. I can't really call it a crime since he was found not guilty, but the deaths that took place as a result of his acts, and his current condition. One of the problems, as far as I've been able to tell, is it seems to be, you could probably speak to this better than I, a fairly difficult thing to predict with any high degree of certainty whether violent behavior is going to repeat or whether it's not going to repeat. But certainly we had a concern based on his past record. On the other hand, when you looked at his behavior within the institution, although there had been a number of violent incidents early on, recently there had been nothing of that particular nature. At the same time, there was no question that he was still mentally ill, that he was having conversations with people that weren't there, that there were indications that he was not entirely leveling with his therapist. So we had some real concerns about whether he'd be taking his medications, whether the improvement that was shown would continue or reach a plateau, remain stable, or once again, once those restraints were removed, if there would be a real public safety problem. And we opted in that case, as you know, to petition for his recommitment. There was quite a bit of publicity and controversy at the time, but ultimately that individual was recommitted for another year. And as you're aware, he's entitled to an annual review. The following year, a review was not sought. Whether there will be a review this year or not,
Oh, it wasn't?
I don't know.
No, I thought it was automatically a requirement. He must have elected.
He can waive that.
He can waive it. Okay.
As I recall the statute, you can waive it, but then if you do so at any time during the following year, you can then request it. So once you've made that waiver, it isn't as though you've lost your chance for the year.
Okay. So what will it take if I'm his psychiatrist and it's time now for a recommitment hearing? He hasn't waived the right to that hearing. What would it take to satisfy your office? And I know your office has standing and can oppose a release, as you did in the first instance. What would it take? What do I have to do to convince you that this guy is ready?
I don't know if you're going to convince me that this guy is ready, given the facts of that murder and the skepticism we have as to the state of the art in predicting future behavior. The comfort comfort that you have is that we are required, if we, or whoever is the party petitioning for recommitment, we are required to prove 3 things beyond a reasonable doubt. And as you know, in a trial, all we have to do is prove guilt beyond a reasonable doubt. But now we have to prove that the person is still suffering from a mental illness. We have to prove that he's a danger to himself or the community. And we have to prove that the plan that we're putting forward, or the place that he's being recommitted to, offers the least restrictive environment consistent with the danger that he offers to the community. So there is a protection there. But if you want to convince us, given that kind of crime, you've got probably a very difficult road to go. Now, if it's a crime of a much less violent nature, much less serious, it may well be that we will be satisfied that the situation is under control and the person can be released. I can think of one case a few years ago, and I wasn't personally involved, so I hope I have the facts right as far as the release goes. But the woman in question was suffering from a delusion that she and her children were about to be hunted down and tortured and murdered. So she wound up killing her own child under the theory that she was protecting them from this torture that they were about to undergo. And there was a trial before a judge. It was jury waived. She was found not guilty by reason of insanity. And I believe within a year, she was found safe to go back on the street. We're satisfied that the treatment program was such that that could be done. But that would be, I would say, the unusual case in terms of our posture as opposed to this one that you've raised with me.
Well, until recently, well, not too recently, but wasn't it the case that people found not guilty by reason of mental illness were in fact spending more time incarcerated than if they had been found guilty of the alleged event? Now, I know that's been changed, but...
I've heard that. I don't know if that's true for Massachusetts as it is nationwide or not. Massachusetts, of course, has if you're found guilty of first-degree murder, that's life with no possibility of parole. And although we're thought of as a liberal state, we really mean it in that instance, as opposed to some other states where there may be parole for first-degree murder. So being aware that you often see the insanity defense if you're going to see it in cases involving murder, I wonder if that held true for Massachusetts. But that doesn't really change your point, does it? That once a person is in by reason of a not guilty insanity, they're in that system, and it's going to be difficult for them to emerge from it properly.
Well, and there has to be at least one person with clinical credentials who steps forward and says, I think this person's ready. And of course, now you're into that whole murky area of can we predict or can't we predict. And I certainly had an example recently where I had to predict whether or not somebody was ready and safe to go back to their employment, which was with a very large state agency. He had a gun, brought it to work. He was obviously deluded. He spent a year in the Bridgewater State Hospital, sort of that treatment system, transferred to a civil system, and then transferred to an outpatient. And actually, your office was overlooked in the transfer process and was quite irate, if I remember correctly, because I think it was all in Norfolk County. But in any event, I then worked with him for a couple of years in a community setting, and then there was the question, was he safe or not to go back to work? And the question came down to under what conditions. And the whole issue of violence prediction is kind of interesting, because I'm very good at predicting violence if you tell me under what conditions. Mm-hmm. Am I never going to see someone again, and I have to predict now for the rest of time? I'm not very good. But if I'm going to see someone weekly, and so the court made clear that this man had to be seen weekly, and several years later he's doing very well, and he never misses any of his appointments. But some of the variables we decided we could maintain some control over. When we don't have any control over the variables, I think then it takes tremendous courage to say someone's ready, if we don't know under what conditions.
It's good to hear that kind of success story, but hard as it is to predict, if that person or anyone else goes out and commits an act of violence, I guarantee you that when you read the press coverage, suddenly it will have been very easy to predict. The question will be how one could have possibly missed, given this person's history, that there might be a future violent act. And maybe that's another problem we have too, that it's very difficult for the press to report on the kinds of subtleties involved in these issues, and the public to appreciate it if they're not caught up in it some way and have some opportunity, if you can call it that, to really experience it.
Mm-hmm. So really, and we have to take a break, I think we've arrived at a time when I think we've come backwards, and it's better to keep 10 innocent people in than to let one guilty person go free. But maybe we can talk about this at the end of the break.
Fair enough.
Oh my God. The fear of not breathing or not being able to breathe is worse than anything in the whole world.
This is a healthy human lung.
My chest gets tight, my heart starts to beat really fast.
This is a lung removed from a patient who had emphysema.
I can't think, I try to calm myself down.
This is full of carbon from smoking.
And I start to hyperventilate and I'm getting no air. There's nothing that's scarier.
It's not easy to quit a 15-year smoking habit. Especially when it's not yours.
Grow up with the belief in English jurisprudence that it was always better that 10 guilty people go free so that one innocent person not be incarcerated. And as I suggested before the break, it seems to me we've come full circle, and I know you wanted to respond to that.
Yeah, that line always struck me as sort of a rallying cry, like give me liberty or give me death. I never thought the person actually wanted to be shot. And I don't know if we really ever believe that we want those 10 murderers out there because we're so concerned about the rights of that one person. I think we like to think that, but that we hope that we have a system where all of the guilty people are convicted and all of the innocent people go free. And so that represents sort of an ideal. And I think that the same ideal is probably a fair one for someone who is within the mental health system as a result of a not guilty insanity or something like that. We'd hope that all of them who have been successfully treated and can be released would be released, and all of them who would later pose a danger do not. And the most useful question, I think, and the hardest question is how to design a system that gets you there. Certainly, I wouldn't pretend that the bias of the prosecutor's office in terms of our role is very strongly addressing those public safety issues. And hopefully, when everybody does their job, the mental health professionals, the defense attorneys, the prosecutors, the judge, we reach that correct result most of the time, and most of those innocent people are going free, and most of those 10 people that are still in need of further treatment in this case are staying there.
Well, you have a lot of faith then in the judicial system. Why is it so slow? A patient of mine was accused of murder. He was a poor fellow, could not make bail, and then those days it was a bail was a possibility, but it was so high. Anyway, he spent 18 months in Charles Street, when it really was Charles Street. I used to visit him on a regular basis. He always maintained his innocence, and it was a self-defense kind of scenario, and the details are not that important, but it clearly was self-defense. He was subsequently exonerated. But it took 18 months before he went to trial. Why is justice so slow?
Well, I think that's a concern that all of us in the criminal justice system have. In part, I think it's the result of good intentions and unintended consequences. Some of it, of course, there's a less glorious explanation. It's just like any large bureaucracy. It tends to take on a certain inertia and life of its own. But there are so many things that are built into the system now as protections for defendants in terms of ordered examinations, in terms of discovery motions, in terms of motions for continuances for all kinds of reasons. The defendant doesn't like his lawyer, that sort of thing. That the system moves along its way. Unfortunately, like other professions, lawyers, we've heard of doctors practicing defensive doctoring. My colleagues in the defense bar often find themselves practicing defensive lawyering, so that just as the doctor orders 8 or 9 tests that he doesn't really think the patient needs, or so we're told if we can believe the press, so the lawyer looks at the case and says, well, I have a real good defense for this person, but here are 7 or 8 other defenses that aren't quite so good, and I better raise all of them or there may be a problem down the line. So we've got the motions filed and the hearings and those sorts of things. And that's not to say that the prosecutors' offices don't share their portion of the blame, but from my perspective, most of the delays in a criminal case result from the requests or the actions of the defense bar.
Usually the defense?
Yes, it's and typically in a prosecution case, delay tends to benefit the defendant in terms of witnesses moving away, dying, losing their memories. Sometimes, I'll give you a little example. This is not an extreme psychological disorder by any means, but I recently had a case with a defendant who had stuck up a couple of Shaw's supermarkets. For some reason, he always picked on Shaw's. He had done the same supermarket twice over in Brookline on different months, and then once over in Cambridge, where he finally got caught. The judge over in Cambridge was persuaded that this was a 40-something-year-old gentleman who had lost his job, had recently developed a gambling addiction, and had just sort of gone off the rails. So he gave that person a fairly lenient sentence where he did a short amount of time in jail and then was on an extended period of highly supervised probation. But of course now I have 2 other armed robberies, and I have victims who have had guns stuck in their faces, and I'm looking for a fairly substantial period of incarceration, a few years anyway, and long probation thereafter. The defense attorney is taking the position, what good is it going to do him? He's in a program now, he's got his life together. So, as far as pushing that case along, there's no interest from the defense point of view, because in this case the person is out, he's on the street, his needs are sort of being addressed by a program. And the hope is that if it's a year or so before the person goes to trial, that then whatever judge that's in front of, you have a track record now that he's been in the program for a year and a half, however long, and judge, look how good he's doing, and why screw up a good situation just so the state can have its little piece of vengeance. So that's sort of a typical example. Now, in the example you gave, there's a person who's incarcerated, so there should be countervailing pressures to move the case along, and unless they think that the result at the other end is going to be unsuccessful or unhappy for some reason, and if that was what they thought, obviously they were incorrect. So I don't know how you give that person back the 18 months. You don't. That's just an unfortunate outcome of an imperfect system.
And that system, how often are you seeing people where mental illness is clearly a variable? I don't mean homicides, but in general the cases that come to your attention.
I think it's probably a small minority of the cases.
Do you trust it?
I'm not sure I understand your question.
Well, sort of the older I get, the more cynical I become. Do you find yourself becoming a little cynical sometimes when the issue of mental illness is raised as a possible defense?
Sure. We become, I think prosecutors tend to be very suspicious and cynical. I'll tell you a quick war story in a moment, but I think the public also becomes very cynical, and the problem again is, I think, somewhat in this tension between the role of the mental health professional, which is to do what's best for the patient medically, and the role We'll leave the prosecutors out of it for the moment, but the role of a defense attorney when someone is charged with a crime is to secure a verdict of not guilty. So if that mental health defense can be used, if there's some basis for it, even if it's a tenuous basis, it may be put forward. Let me tell you about a motion for new trial that was ultimately denied.
About 2 minutes.
Okay. A gentleman was incarcerated in Norfolk, got a gun, led a little insurrection, and wound up shooting a prison guard between the eyes. The guard had glasses like mine, broke the glasses, the guard lived, amazingly. Was convicted. 12 years later, motion for new trial on the grounds that he was not competent at trial because he was suffering from post-traumatic stress disorder. And what do you suppose was the traumatic event that caused him to be suffering from post-traumatic stress disorder?
Incarceration.
No, it was the pain of seeing that officer that he shot between the eyes. He just kept having flashbacks to it and couldn't focus on the trial. Now, could anyone blame me for being a little cynical about that particular defense?
We're both smiling, so I think we agree on that one, certainly. All right, well, maybe after the break we'll pick up on some of the lessons we can learn from some of these cases and apply them to families.
Sure.
What would you do if you had to choose between the buffalo and the giraffes? Between a flower or an elephant? What would you choose? What if you had to decide between a 100-year-old tree and a 1,000,000-year-old beach? Between drinking clean water or breathing clean air? Would you make the right choice? Would there be a right choice? Now there's a way to help. Not just one, but all these things. EarthShare, the world's leading environmental groups working together. It's one choice we can all live with. Ask your employer about workplace giving.
Talking a little bit about the John Salvi case, and I have some interest in that as well because the Salvi report out of the University of Massachusetts hopefully will become a vehicle for improving some of the services available to the mentally ill. What have we learned, or what has your office learned from the Salvi case?
Well, I think there's a lot of lessons to be drawn from the Salvi case. Maybe one of the lessons to be drawn in terms of family members is that although predicting the future is difficult, hindsight is 20/20, and certainly I think when the members of Mr. Salvi's family look back at some of the things in his life, we can see where possibly if he had gotten some assistance sooner than he did, there wouldn't have been this kind of terrible outburst. Certainly I would urge family members, if they think they see a problem, depending on the degree of the problem, they should do their best to get this person to a mental health professional. If violence and crimes are becoming involved, the chances are if that person isn't getting treatment, there's going to be an escalation. Mm-hmm. So that may be the time to call your local police, call the district attorney's office, if it's an issue involving spousal abuse or child abuse, something like that. And in particular, our office has people that are very well trained to work with victims in this sort of situation. And the terrible thing when mental illness is involved, I think, is so often the victims may be outsiders, but the victims are very often members of the family, so that oftentimes out of a love or a desire not to be seen in an accusatory role, or for whatever reason, they will delay taking the steps that might have helped this person or averted a tragedy. And then after the tragedy happens, the remaining family members may be victimized again, either by the system or their very ambivalent feelings of wanting this person now kept under control, but feeling guilty for those very feelings. Certainly there are other, and don't want to go on in a monologue here, but certainly there are other lessons that can be drawn. I think one of the good decisions that was made in the Salvi trial was Judge Dorchakara's decision to ban live television coverage, because the Salvi trial, by virtue of the fact that the murder occurred at an abortion clinic, and all of the implications of that and that controversial issue, that people had very political feelings on one side or the other about this trial. And I think whatever flaws the ultimate trial might have had, when the trial started, it did progress in an orderly and very expeditious fashion. There was no live press coverage, and I'm very aware in terms of time sequence that it followed fairly shortly in time the O.J. Simpson trial, and certainly I think Massachusetts jurisprudence looked quite a bit better in the Salvi case than things looked like out in California.
But did the mental illness have a chance? I mean, it sort of got lost, I think, in the political shuffle, the need to dispose of the Salvi case, and yet there seemed to be some very legitimate mental health concerns, and where were they?
Well, I think they were front and center. There was a complicating factor, of course, in Salvi, in that I believe his very capable attorney, Jay Carney, thought that he was not competent to stand trial. And Mr. Salvi himself, as I understand it, was adamant that he was competent.
Right.
So there was that conflicting duty, and ultimately the court appointed a special attorney and to proceed on that issue of competency, and adjudicated him incompetent. And again, the jury found him to be criminally responsible. Now, some people might quarrel with that result, or wonder, what sorts of things were driving the jury, and maybe there's an argument to having judges making that decision, or a tribunal of judges and doctors, or whatever. But as of now, we've got the jury system, and certainly that was an issue that was
But
every opportunity to put before the court.
well, except that the court chose to hear what it wanted to hear. I mean, when I've testified many times around issues of competency, and I don't know, 80% of the time, 90% of the time, if I feel someone is not competent, I can almost be assured that they will disagree with me and argue that in fact they are competent. Now, it may be painfully obvious that they aren't competent, or it may be something in a gray area, but you can't expect necessarily your clients to agree with you if you're asked to make certain decisions about, their life. But let's take some of this back to family members. Often I think when families are ready to pull their hair out because they don't know what to do with a family member who is out of control and not behaving very well at home, not medication compliant, very negative. Many times people like me will suggest they turn to the courts, that they see if in fact through the criminalization process, pressing charges, they might get some assistance. I wonder what your experience and your thoughts are about that.
I think certainly if the person that they're concerned about is committing criminal acts against family members, is getting violent, something of that nature.
Well, even threats.
Or even threats, sure. That's a route that they should seriously consider taking. And whether they call their local police, and certainly if they're experiencing a threat of an immediate nature, that's probably the best way to go. If the situation is such that they have a little more time to consider, they could call our office if they were uncomfortable doing that. They could call in Norfolk County, the Norfolk County Bar Association, for example, and ask that they be referred to an attorney who could perhaps advise them of what their rights might be, either criminally or civilly.
But they could call your office.
Sure.
Okay.
Sure. We have, as a matter of fact, an assistant district attorney who is assigned each week with the responsibility of taking calls from the public, and to the extent we are able, we can't sell people cars or things like that, but to the extent they have a legal problem that the criminal justice system touches on, we try to give them an answer or refer them. I think of one of my old law school professors. He used to teach torts, which is the branch of law dealing with accidents and negligence and that sort of thing. And one of the sayings that he liked to reiterate to us a lot was, better a fence at the top of the hill than an ambulance down below. And I think there's some application of that to these sorts of situations. The sooner these problems can be dealt with, the easier it is to keep them at a relatively low level. But once you're walking into the abortion clinic shooting people, the situation has escalated to the point where the lines are drawn and the guns are literally have been pulled out, and it's going to be very hard to do anything to help that family member.
So there are situations where turning to the criminal justice system may be very therapeutic. It may be the kind of intervention that the situation demands?
Yes, we have some judges. We were mentioning at the break Judge Richardson, who recently retired, who have a real interest and expertise in this area, and oftentimes the courts can be very helpful.
Very helpful. Yeah, I hope to have him as a guest. I've already spoken with him. He was always a real supporter of our efforts to sort of improve the quality of care at Bridgewater State Hospital, for example, which is the DOC's major facility for taking care of people pre-trial as well as post-trial who have been accused or adjudicated as committing serious offenses. Well, I want to thank you for being here. I found this very helpful, and I think, for example, I did not know that people could turn to your office as a resource just in terms of getting some guidance about where to go, and it would not surprise me if you do get some calls from members of the Norfolk Alliance.
Well, I hope we do. I hope that the important thing is that they turn to someone as a resource and get referred to whatever place can be helpful to them. So if they're not comfortable talking to us, I hope they seek help where they are comfortable. Don't let the situation go.
Well, thank you very much. I appreciate you being here.
Thank you. Enjoyed it.